Part 2, Overview of a Tennessee General Sessions Civil Court Case. In Tennessee, General Sessions courts can hear both civil and criminal cases. Criminal cases are for people charged with a crime. Civil cases are about things that are not crimes, like contracts or divorce. This video is about the Tennessee General Sessions Civil Courts. General Sessions Civil Courts hear many different kinds of cases. Some common types of cases heard by the Tennessee General Sessions Civil Courts are cases about contracts, cases between landlords and renters, and cases involving damage to land or personal belongings. General Sessions courts are sometimes called small claims courts. That means the money or property in the case is worth less than $25,000. But sometimes the amount of money involved in a General Sessions civil case can be more than $25,000. General Sessions civil courts can hear any case in which a landlord is trying to evict a renter, even if the landlord is claiming that the renter owes more than $25,000 in back rent. General Sessions civil courts can also hear any case in which someone is trying to get their property back from someone else, even if that property is worth more than $25,000. Do you want to sue someone in General Sessions civil court? The facts of the case decide where you can file your lawsuit. You can start a lawsuit by filling out a paper called a civil warrant and giving it to the court clerk. This is called filing the civil warrant. The civil warrant says who you are suing and why. Usually, you can start a General Sessions civil lawsuit in the following ways: filing in the county where the person you want to sue lives, or in the county where the property or money in the lawsuit is. If the lawsuit is about a contract, by filing it in the county where you signed the contract, or in the county where the work in the contract was done. If the lawsuit is about injuries, by filing in the county where the cause of the injury, such as a car wreck or a medical procedure, happened or occurred. The person who files a lawsuit is called the plaintiff. That person will be the plaintiff on all forms that are filed with the court. The defendant is the person who is sued. The plaintiff and the defendant are called parties to a lawsuit. To start a case, a plaintiff files a civil warrant with the General Sessions Court Clerk's office. Each county has civil warrant forms the plaintiff can use. Here is an example of a civil warrant from Shelby County, Tennessee. The civil warrant is not the only form that can start a lawsuit. For an eviction case, the plaintiff can file a forcible entry and detainer warrant. In a case where a plaintiff wants to sue to get back personal belongings from someone else, that plaintiff can file a warrant to recover personal property. When filling out the civil warrant, make it clear who the defendant is that is being sued. Put exact names and addresses on the civil warrant if you can. There is also space on the civil warrant for the plaintiff to give the reason or reasons for the lawsuit and the important facts about the lawsuit. The civil warrant does not have to say what the law or the legal claims are, but the civil warrant should say why the lawsuit is being filed. In order to file the civil warrant, the plaintiff must pay a filing fee to the General Sessions Civil Court. The court clerk's office knows how much the fees are. If the plaintiff cannot pay the filing fee, he or she can file something called an affidavit of indigency. An affidavit of indigency asks the judge to let the plaintiff file the civil warrant to start the lawsuit without paying the filing fee. It is only for people who can prove that they have low or no income. If the court approves or okays the affidavit of indigency, the plaintiff can file the civil warrant without paying a filing fee. The plaintiff may have to pay the filing fee later. After the plaintiff files the civil warrant, the General Sessions Court Clerk writes a paper called a summons. This paper must be given to each defendant with a copy of the civil warrant. Giving the defendants the summons and the civil warrant is called service of process. This is how the defendant gets official notice that he or she is being sued in General Sessions Civil Court. After the plaintiff files the civil warrant, the General Sessions Court Clerk writes a paper called a summons. This paper must be given to each defendant with a copy of the civil warrant. Giving the defendants the summons and the civil warrant is called service of process. This is how the defendant gets official notice that he or she is being sued. The person giving a civil warrant to the defendant must be 18 years of age or older. The person giving a civil warrant to the defendant cannot be part of the lawsuit. Afterward, the person who gives the civil warrant to the defendant must give the court clerk's office proof that the defendant got the civil warrant. A plaintiff may want the county sheriff's office to give or serve the civil warrant to the defendant. The plaintiff can do this by paying an extra fee to the court clerk's office when the civil warrant is filed. A plaintiff may also pay a private company to give the warrant to the defendant. Sometimes, the plaintiff may not be able to give the warrant to the defendant. The plaintiff should try again within 9 months from the date the civil warrant is filed. If the civil warrant is not served or given to the defendant within 9 months from the date that it is originally filed, the court may drop the lawsuit.